And I saw Marion just came in, so I want to make sure I get that logged in. And okay, so here's what we have. Tonight I have actually two guest speakers for you. I don't think they're each going to take an hour unless you guys start asking lots of questions because you really don't want to listen to me. And that would be understandable, so it's okay if that's what you do. However, what I really want to do is, well, we'll get into that. We're going to talk a little bit about real property. I have a good grammar fun called the You Don't Say edition. We're going to talk a little bit about the Fair Credit Reporting Act, because, just a little, because we have a case that was held over from last week. Then we're going to talk about being in the rental business. I have a final exam review, and then we have a second guest speaker coming in at about 8 o'clock. So our first one should be in any minute now. So housekeeping issues. I still want to encourage anybody who hasn't to register for summer and fall. I keep mentioning this, but it's actually in many ways a good follow-up to this class.
I have no clue.
My intro to logistics class gets a lot into some of the regs and processes for importing, for shipping arrangements, when, shipping contracts and how they pay and when they pay and all of those kinds of things. So if that interests you, I will be teaching it online. It's LOGM 127, so keep that in mind. Second is the business formation project. I noticed as I was going through them that in a couple of cases, well, a couple of you reached out to me at the time and I showed you how to save them. But I noticed in a couple of cases, you just downloaded the form and you didn't complete it. And I know that's because you weren't able to save them. And here's how this works. Is if you have a form like this, so I just took this one form and I called it test business and put my email address. And if you go to save it, it won't save. This is one of those fill in the blanks and print them types of forms. But if you print the form, so you hit the print button, and instead of going to my printer here, if I do print to PDF, then that will save the document, as if it were printing it, and it will, and you'll be able to upload that document. So in a couple of cases, if you just have the blank document and you want to submit the one that's fully completed, it doesn't take long to do most of these forms. Go ahead, go back, and then resubmit it. Because when I save this, in fact, let me go ahead and, in quotation marks, print it. And it's going to, yeah, this is fine. Save. Oh, it needs a name. And if I go back and I go to drill into my documents and Ivy Tech and Business 201, and where did my test one go? There's test. And so when I reopen it after I printed it to PDF, you will see that the test business and my email address are there. So if you want to go back and do that, feel free. Okay, I'm going to close out of that. And we need to get our PowerPoint back. So from the current slide. So third, grades are due 1 week from today. That means I have all day Tuesday to score any last second things. So anything that you get me, if you're backlogged a little bit on assignments, anything that you get me, By midnight on Monday, I will guarantee you I will get it included in your grade before I submit them on Tuesday. If you happen to have any stragglers after that, you need to reach out to me. You need to contact me, and I will tell you if it's worth your time to do it or not. But always remember, even if you submit something late, the reduced points are better than 0 points. So I encourage you to get any backlogged assignments in if you can. Okay, let's go on to, and so let's go on. Our guy Tom should be joining us any minute, and I'll start into the next material while we wait. But I sort of expect him. It's well, I told him come in about 10 minutes after, 10 to 15 minutes after. So, but I'll still give you the introduction. The first speaker we're going to have in, his name is Tom Howe. I have known Tom for quite a while. In fact, I've known him since 1974. Tom got his bachelor's degree in economics from Notre Dame. He got his master's degree in finance from the University of Chicago, and actually had the opportunity to study at University of Chicago under 2 Nobel Prize-winning instructors, George Stigler and Milton Friedman. So that was probably pretty interesting for him. He and his brother Dan founded PTI Securities in Chicago, and they've been running that business for about 18 years. Tom is the chief investment officer. Dan's the president. Tom's also the host of the Stocks and Jocks podcast, where you can hear me on every Wednesday and Friday. And he is in the past, he was on the board of directors of the Chicago Board of Options Exchange. He was the president of the Professional Traders Institute for those years, and started out his career as a senior financial analyst at Pullman, where they make trains. And I see that Tom is here. So just as I was introducing him, there he is. So hi, Tom.
I caught you before you said something bad.
What, about the fellow ancient?
Yeah,
I already told him that. I told him that. I told everybody that first.
Oh, God. Okay. How are you?
I am doing okay. And I think the class will be interested in what you have to say. Just for everybody's edification, as a follow-up to Ryan Mathis's visit last week, who is an auditor, I thought it would be interesting for you to get some perspectives from somebody who is on the receiving end of many an audit. So, Tom, I'll let you just start talking for a while.
Well, where do you want me to start? Do you want me to start where regulations started in our industry, where it started anywhere, or where do you want me to start?
First of all, tell them a little bit about PTI Securities and what you do.
PTI Securities, back in the day, a bunch of guys all worked for me, all traded on the trading floor of the CBOE. I traded in the OEX pit, and it was 350 people. It was the 80s. It was the stuff you see in movies now. And I had a bunch of people that worked for me, and it struck me as I moved up the chain at the CBOE and got on various committees and so forth that a lot of what the problem was with options was that the investing public didn't know very much about it, and the firms that was the distribution system, the Merrill Lynch's and those kinds of people, really didn't care much about the product, and really were not about to help the exchange out for people to trade more, because I think it actually could help people's accounts. I mean, there's a lot of things you can do with options you can't do with stock, but this is not about that. So we ended up putting together a program where we went out into the world, shall we say, and did lectures and so forth for people to trade options, how to do it, different tutorials, different ways of this strategy, that strategy, how to help people, even found ways for people doing their IRAs, those kinds of things. So we really pushed into the area of retail option trading as a way to make your portfolio more conservative, not really less, although options can make it very, very racy if you want to. Then it occurred to us that, hey, there's no real firms that are doing this that really want to have this product, even though a lot of them had it, sort of by default. So we decided, okay, we're going to form a brokerage firm. And we started PTI Securities And like, don't ever do this. We took 8 people off the floor, sat them in a room without a customer. I mean, when you start a firm, you're supposed to have a bunch of people that have like customers and so forth, things like customers, and you're supposed to come to one place and start a firm. In those days, you actually could start a firm pretty easily, like 25, 30 grand. Once everybody took their test, you were good to go. So we started this firm, and it took a while, but eventually we did pretty well. I spent another year or two on the trading floor, essentially financing the place until it was able to go on its own. And then after a long period of time, in 2000, maybe 9 years after we opened, I realized that there wasn't much going on the trading floor, like there isn't one anymore, or very little. And we had many more people upstairs that wanted us to actually manage money for them. So I left the floor to do this, and instead of standing down on the floor, obviously if the floor was still there, I might still be there at my advanced age, because it was fun. I mean, we could do a whole class someday on what it was like to be on a trading floor. You guys would be absolutely stunned of what the world was like in those days. Talk about the Wild West. None of that happens today. But PTI, when we started, we actually, some of the people that came in to do our first audits and so forth, from then the NASD, in those days, the exchanges and the NASD all had their own regulatory departments, because you were a member, and they were called self-regulatory organizations. So the idea was, New York Stock Exchange might do an audit one time, it's a CBOE the next time, the MX the next time. I don't know if you know, with the American Stock Exchange, I'm throwing these terms around, well, which I probably shouldn't be. The CBOE, Chicago Board Options Exchange, you might have the American Stock Exchange, you might have the New York. Once in a while you get like the P-Coast or somebody, but by and large it was those firms that would come in, and they were really good guys. They recognized you were new. They'd say, wait a minute, you guys are doing this all wrong, do it this way. They were sort of there to help you out. They knew we weren't cheating anybody. First of all, we couldn't cheat anybody. We didn't have any customers, but even if they kind of had the feeling we weren't that kind of firm. And the regulatory group was part and parcel of the industry. But not that they wanted anybody to cheat, but they didn't. As time went by, the regulatory part became very politicized. And this has happened in other areas as well. I mean, we could start from any industry you wanted, really. Railroads is a good one, because that's where all the regulation really started, but let's leave that for another day. So all of a sudden now the NASD and all these exchanges, as they became more and more competitive, they wanted out of the regulatory area. So one day somebody got an idea to make the regulatory area essentially a for-profit organization. So all the exchanges in the NASD who had done all the regulation formed this outfit called FINRA, which is now the regulatory group that everybody uses, and they essentially make their money from fines, which is a total different attitude toward the world than like the CBOE used to have, or the New York Stock Exchange. I mean, they didn't want anybody cheating clients, but they didn't see the regulatory area as a profit center, which I think most of you would sit there and go.
What you're saying is their livelihood is all about catching you doing something and fining you for it.
Correct. And then they end up with a lot of, like, rightly, either intentionally or not, they'll end up with like minimum fines for things that the same might be for Merrill Lynch than for PTI. Well, Merrill Lynch, they have a group of people at that level. You essentially have a bunch of people who are just, I use the term, play with the regulators. How many we have here today? 20? Okay. How many people we've got on it? 20? It's fine. And if they come in and say, you've got these 5 infractions, by the way, the total fine is 20 grand. Oh man, that's terrible. And they walk out and have a beer saying what a great audit that was. But PTI can't afford to pay 20 grand every time somebody walks in the door. And you have 3 or 4 people that will sit here. Sometimes they've outnumbered us. We had 6 people at one time. We had an audit from the NFA, because we're a futures firm too, National Futures Association. FINRA was here and the SEC was here. So we had 9 auditors and 5 of us. And they were in 3 separate parts of the office. And nobody would leave until like the other guy left, because they didn't want somebody else to find something that they didn't. It was the most ridiculous 2 weeks I ever spent. And none of those people could sit there and go, God, this is crazy. We're all doing the same thing. What are we doing here? It doesn't matter. It was Christmas time, and all those offices were in Chicago, and nobody wanted to go on the road at Christmas. So in December, we had 2 weeks of these 9 idiots in here, basically. And we never got fined by anybody. We had 3 exit interviews. We never once got anything that said we were okay from any of them, because all 3 of them were afraid that the other guy found something and they didn't want to give us an all clear in case the other one didn't. I mean, we're talking about money, not very well spent on their part. And it really reaches, and now every year you get this is where it's evolved too. Last year, our last audit, the big thing was on outside activities. We've got 5 people here that are 60 years old. Well, one of the people that's still on our board is my girlfriend, who's in the business forever, and she still has her license, and once in a while she'll find a customer or she'll help us out, but it's not her full-time job anymore. She does real estate. They spent 2 days on going over her real estate stuff. You guys got to be watching real estate stuff. Why? We're not a real estate firm. It's something separate. Yeah, but you got to supervise. So now it's evolved into this. I know you guys are adults. You can't just go to the bathroom. You need procedures. You need supervision. Somebody has to watch you. Somebody's got to check it. And oh, by the way, if something bad happens in there, not only didn't you follow your procedure, the person who was supposed to watch you. So everything you do now, if there is a mistake you make, it's 3 mistakes, because you just didn't screw up. Your procedures didn't tell you not to screw up, or you didn't know the procedures, and nobody watched you. So we've reached kind of the absolute absurd stage at this end, and a lot of industries are sort of like that. I mean, banks are the same way. I mean, I'm sure Mr. O'Neill, Kevin, has mentioned that the burden for of a huge bank is relatively less than it is for a neighborhood bank, because you don't have 5 people where their only job is to play with the regulators. So it ends up being, even if it's not intentional, it ends up being, I get a letter every 2 weeks from somebody saying, would you guys like to combine with us? We know the regulatory pressure is something you can't handle in a firm that size. But I just happen to be an old stubborn guy, and when I leave, it's going to be my place that I leave when it's my turn in the grave. But you know what? I would never start a firm like this now, ever. And if somebody said they wanted to buy it, I'd say, you're out of your mind. I mean, the amount of time you spend hacking around. I'll give you a little example. This is very recent, and you'll think this is crazy. We took in another partner a while ago because we wanted to do some different stuff. The guy comes in. He's never had a problem in his life, right? Well, with this COVID thing, he's now, because he gave us enough money where he's over 5%, he's considered a control person, even though he is never going to be in control. He doesn't know anything about the place. He just wants to be in. So the COVID thing comes up, and one of the things you have to do is to submit people's fingerprints so that the NFA or whoever can run the fingerprints and find out if the guy's an axe murderer or whatever. So they decide to shut down, so they won't accept any fingerprints. This has been 2 months now. So they keep saying, well, we need fingerprints, but by the way, you can't give them to us. So finally they write up a new rule 2 weeks ago. It says if you don't have fingerprints, you have to do a background check on the person using some service, and if it turns out that you certify that he's not an axe murderer, basically, and it turns out the fingerprints show that he is, now you're in hot water because you certified a guy who was a criminal. So my brother, who was the president of the place, calls these guys and says, well, who do you use? Oh, we can't tell you that. What do you mean? He says, well, you're like the first guy, so we don't know what you're supposed to do, but we are telling you better do it right. The guy actually said that on the phone. So they said, well, you don't have to do it right away because the thing just came out last week. 4 days later, they said you got 6 days to get it in there or we're shutting you down. Shut us down. On a rule they conjured up a week and a half before because they're closed. This is the level at which it's reached for small places. I mean, this is far and away different.
The important point to reemphasize is as we go back, and I know I've said this in class before, is that you get a lot of really big companies that say, oh, no regulation, please don't regulate us. But what they're really doing is saying, please, Brer Rabbit, don't, it's like they know that it hurts you more, that it costs you just as much to do all of the compliance activities as a small company as it costs them as a big company. The difference is they can afford it. And so more regulation, it often is done in the name of the little guy, and it tends to benefit the big guy.
Well, it also for the big guy, and this is not something actually, Kevin, you and I have talked about on the show, but for the big guy, you absolutely want a regulator because he is a buffer between you and the criminal justice system. I mean, for instance, if you were Merrill Lynch or somebody and you totally screwed people out of some whatever commissions or probably more like fees, but if you did something nasty to the tune of a couple $100,000, you could get a $300,000 fine. But that's a lot different than it going to the Justice Department and you getting a felony conviction. The biggest example of that was Arthur Anderson. The accounting companies for years fought and fought and fought. They never had a regulator of any real kind. They had a self-regulation group there, but they never had a federal regulator. There wasn't like a FINRA for accounting firms. And then when they got in trouble, they ended up in criminal court. That particular thing they did, I'm going to say with a regulator would have been $1 million fine at worst. And they ended up folding up, right, Kevin?
Yeah.
On the one hand, yeah.
For everybody's education, if we go back to when we discussed Enron and Sarbanes-Oxley, this is, Arthur Anderson was just as involved in the fraud as were, Enron and WorldCom and everybody else involved in those days that caused the legislation in the first place.
Right, but for a lot of, like even on something that would happen on the trading floor, when I first started, I'll go through this quickly. Every trade, like in IBM options, took place in one spot on the CBOE. Every trade in the OEX options where I was took place in one spot. So everybody heard every trade. So the design was not that people were good. Mostly people think traders are thieves, which would be absolutely wrong, by the way. The most honest people I ever met. You got to police the order. So if everybody's quarter bid at 3/8, and somebody goes in and says, "I'll pay a half," immediately a hue and cry would go up. What are you doing? We're all at 3/8, you idiot! Don't pay a half, which is essentially stealing. Well, as they started the dual list options to where they were at different places, a lot of times the member firms, if it was a juicy trade, they'd like to take the other side of it, which is, again, on everybody's head here, but they would come into a crowd and they would say, we're going to pay a half for this, even though you guys are at 3/8. We want to do half and we'll split the rest up. Well, in the unlikely event they were ever caught by the CBOE regulatory or somebody, that would institute a fine or something. Now, but somebody, if that's 1,000 lot, somebody just stole $12,000. Well, in most cases, a felony is $100. So if there was no regulatory group to go to, that group, in addition to having a lot of good things happen to them vis-a-vis a firm our size, they were never going to get an exchange to spank them because Merrill Lynch was too important to the CBOE. So if they ever really went over the top edge and got themselves in trouble, they could get a $1,000 fine for a guy, happening to screw up instead of intentionally stealing. Well, if that ever got in the criminal justice system, Merrill Lynch is in big doo-doo, right, Kevin?
Yeah.
So if you're big, the regulator is not only your best friend to keep competitors out, but also your best friend to keep you away from the criminal justice system.
Okay.
Which is not exactly the design.
Let's shift gears a little bit. And would you talk about the process? First of all, when do you know that the outside examiners are coming in?
Well, now it's become different they have a portal now. It used to be they would just say, we're coming there next week, and 3-4 people would show up. And then if you ever, most everybody now has a regulator. We used to be able to do it all in-house. Finally, we said, there's no way. We have to pay somebody a couple thousand a month to be our, quote, regulator. So they're involved with maybe 10 different firms, so they start to know the questions that are being asked. So they'll come in and they'll sit down with Dan and say, this is what everybody's looking for. Go through the stuff, get it ready for them in advance. Well, now they do almost like these virtual audits. You don't even know the people. You just get through your portal from them. Dan will just open a thing one day, and there's 25 different requests that might take him 50 hours to do. You don't even see the people. Then you send it in, and they'll come back and say, need another something. You don't even know what they're looking at. So now it's become this electronic Like they never called us and said, we're going to put you out of business if you don't get this guy's report in 5 days. All of a sudden, he looks at the portal and goes, wait a minute, we got 6 days. So the process has changed, Kevin. Now it's, they demand all this stuff online, and then if they don't like it, they'll either demand more or they might come in. But literally, they would come in here, and we might have 1,000 clients, and we peaked out probably 1,200. They would come in with 3 people, and they'd go through, 500 books, or looking for a missed signature, looking for something. Well, if they went to Merrill Lynch, it's got 1 million clients, they might do 2,000. The difference is dramatic, especially if you're sitting there playing with them the whole day. So yeah, I mean, it's gotten like totally out of hand in a lot of ways, and there's no bringing it back, Kevin. I don't think, because the object is the investment public demands more regulation. We need more. Well, what does more mean? Nobody even can define it. We just need more. I mean, I don't know what else would you like me to just answer away? I'll answer any question.
Well, one other thing I'd like before we throw it open for anybody to ask a question is, and this is just completely different. It's not specific to securities, but when you were talking about it, I think this morning, I thought, oh, that would be good because we have a lot of aspiring business owners here. Can you talk about some of the things of just running a business, some of the compliance types of things? And the thing that triggered me was that your comment about the sales tax audit.
Well, we had anything that's, well, it depends on where you're at. I mean, obviously in Chicago, things like that are a lot different. You also have clients that now it's well, there's two sides. One is on the client side. If people lose money, there's all kinds of attorneys that are willing to take a case to arbitration, and probably for bad things the industry did years and years ago. The arbitration is very customer friendly, which is fine, except for the fact that it takes a lot of money, and the big firms are sort of involved in this. If you had any kind of a minuscule case against Dean Witter or somebody, you just walk in the door and they'll immediately thought, you say, well, you owe me $500,000. I lost that kind of money at your place. They're going to say, what's the cost to litigate? 80. Tell the guy we'll give him 50 and get the hell out of here. Well, once people start doing that, you develop this whole group of attorneys that's all they do. They might file 10 of these things a month, and it'll be $1 million. Oh, by the way, we'll take 50 today. And it's so you have that from the others. There's no pushback there. I mean, because it's all done on continuous. They know the game. It's all in the arbitration area, and maybe even in their building if they're that kind of firm. So you have that going for it. But you also have the other stuff. You're part of a city. We had the city of Chicago guys walked in. This is how crazy it is. More than anybody needs to know. I have a chiropractor out in the southern burbs. I was going one day a week, and we were doing seminars for people and everything. So I'm stopping at the Sam's Club in Hodgkins, buying pop for the seminar and coffee, and we're doing a seminar like every Saturday morning to trade options. So I might be buying some croissants, whatever it is. I get here, and this guy shows up in person, and he says, by the way, we're doing a Chicago sales tax audit. And we go, what the hell is that? And he goes, better make sure that you're buying your stuff in the city of Chicago, or like there's a big fine. Really? So the guy goes through all of our receipts, where we bought our computers, where we bought anything. And if he finally gets to the point, thank God the Sam's Club cuts out the food from the other stuff. It turns out we were within $10 because over 50% of the stuff I bought was food and pop and things for seminars. We're within $10 about getting a fine for shopping in Hodgkins and not in the city. But this went on for a month, giving this guy every receipt we had and the whole bit. I mean, you don't know where this stuff's going to come from. It's crazy.
Yeah, and I want to fill in the blank a little bit on that. What most of you probably don't know is that the city of Chicago has an additional sales tax compared to the rest of the state of Illinois.
And the county.
And the county has a separate one, right?
No, this place I went was in Hodgkins. They were in Cook County, but not in Chicago. Okay. So they're like 1% less.
So the point is that they were coming in to audit and say you should be buying your supplies in Chicago, and we're going to fine you if you haven't paid Chicago sales tax, because you're not allowed to go outside of the city limits and bring stuff that you buy back into the city.
So, and the accusation is that for $2,000 worth of stuff, I purposely drove to Hodgkins to save the city's 1%, which I'm not sure anybody would do, Kevin.
Yeah, it's crazy. Okay, we'll throw it open for questions, and so you ask Tom anything you'd like to know, and otherwise we'll send him on his way. So does anybody have a question?
I do.
Yeah, fire away, Brock.
So you still do seminars on options?
We don't do as many as we used to because a lot of people don't necessarily want to learn as much. Let's put it that way. It's a good question, by the way. I used to go to seminars all over the place where we taught people how to do. Some guys would teach, technical analysis, fundamental analysis on stock, and we would teach options. Now it's to the point where most people don't really want to learn to do it themselves. They want to just give their money to people and just pay them a fee and other people manage for them. But we have a lot of clients that want to come in and they'll talk about a strategy and we'll help them do a particular strategy. Most people, for instance, if you're an IRA and you want to protect it, maybe there's a put buying strategy or a covered call writing strategy, that type of thing. People aren't as anxious to do their own trading as they used to be. So we don't do the full seminars, here's how to trade options from start to finish like we used to. People used to give those seminars, people would come and spend an entire week with these seminars. We never did that. We came 1 or 2 days to talk about what we did as guest lecturers. But there were guys that actually spent 7 or 5 straight days teaching options. It's a fabulous product and really interesting, but I don't know if anybody does that anymore.
If you do still do them, where would I be able to find information on that?
Just come to PTI, just send me an email, and we'll find somebody.
Yeah, so how can everybody find you if they wish to find you, Tom?
Easy, Tom at PTIsecurities.com. Yes.
Tom at PTIsecurities.com. Or you reach out to me because I have his contact information too.
Actually, the funny thing, Kevin, if we start getting some crazy inflation, which I think the Fed's trying to do to us, nobody trades commodity futures anymore. People used to love to do that. Corn, soybeans, oats, that kind of stuff. Nobody does any of that. But someday that'll come back again because that's a lot of fun. Well, if you make money, it's fun.
Okay. Any other questions? All right, Tom, thank you so much for coming in. We will, I will talk to you in the morning, bright and early.
Okay, bud. Yeah, we got stuff tomorrow for sure, huh? The market only dropped 90 points in like the last 20 minutes. As soon as
yeah, well, that's not my thing. You can talk about that with Russell when he gets there.
Well, your buddy in California said we might have to stay shut 3 more months, and I think market didn't like it much.
Yeah, well, yeah, California's got a little bit of impact on the economy.
Yes. Take care, guys. Thank you for having me on.
Okay. And now,
Thank you.
and now I was expecting our next guest a little later, but I see that she's here, and we're going to move right to it.
Mr. O'Neill.
Yes, sir.
I didn't know if you saw my message, but I'm here. I was a little late.
Oh, I got you. I got you logged in. We're good.
All right, cool. Thank you.
Hey, Kevin. Hi, everybody. You don't have to include me now. I just got on just to listen to the class.
Oh, okay. Well,
yeah, you can just go on your regular schedule, and you fit me in when you're ready.
All right. Well, we'll do that. We can do that. Okay. So, as I said, we have a lot to do today, so we're going to pick it up with we're going to talk just a little bit about real property and just make sure that we hit the highlights of this, because it's pretty it's one of those areas where you deal with it in the as you conduct your business, but you also deal with it on a personal level. Many to most people do sometime in their lives. So the first thing I suppose is we need a definition, and it would be too easy to say that real property is the opposite of unreal property, but really it's pretty simple. It's land it's the buildings, plants, and trees that are on the land, it's airspace rights, and to a point, it's water rights as well. So if you're on water, you certainly don't have, you know, rights to, you know, the whole lake or a percentage of the lake, or whatever the body of water is, but you do have access rights to it. And so that's part of it as well. Think of it like this: if it's not movable and it's part of the property, then it's part of the real estate. There's different kinds of ownerships, and it's real simple. If you're like me, you're the sole owner of your property, and that's pretty easy. It doesn't create any complications. When my time comes, it'll go into my estate and be payable through my will, and that's, you know, that's all taken care of. But it's when you get multiple owners, and there's a couple of ways that you can do this. You can have tenancy in common and joint tenancy. Okay, and there are lots of reasons. Can anybody want to throw out ideas as to why you might have multiple owners of a property?
Marriage.
Marriage would be one, yep. Spouses definitely, you're almost always will share ownership of a property. What else?
Build up credit.
You might want to, yeah, you might have somebody come on a property with you because you need to build a credit rating. That's a good call. Anything else?
Share costs.
Could be to share costs. And it could be, the picture here might give you a little bit of a tip of it. Could be a shared investment as well. Okay. So if you have tenancy in common, that's just multiple owners, each of which one has a percentage ownership. And so what happens is, and the example I gave here was this fishing shack. You might have, you know, some friends who decide they're going to go in on their fishing shack so that they can go up and, you know, pitch a tent or whatever at this place. I don't know if I want to go in it. But they may very well do something like that. And as a percentage owner, if I die, that percentage of the ownership gets passed to my heirs. Okay, and that's how tenancy in common works. Now, the other kind of multiple ownership is joint tenancy, and that's really what's typical of spouses. That they share an undivided interest. In other words, they're a way to look at it is it's as if they're both 100% owners, and therefore there's a right of survivorship. If I die and my spouse lives, my spouse becomes the 100% owner of the property. So that's an important distinction that you need to make when it comes to real property. Now, you know, title gets passed via deeds. And the deeds have a number of important components to them. Certainly it has to have the parties' names. This is not all that different from when we discuss negotiable instruments. It just it's logical when you think about it. But you know, it's typically, you have an intent. I hereby sell would be an example, or I hereby transfer ownership or something like that. You're going to have a description of the land, which you see over on the right. And that description has to be a legal description. It has to be very precise. Those of you who have bought a house know that you'll see things like what you see on the bottom here, where it says property having lot number 146 within section number 785, and it'll give you a township name, or it might give you a city name or something like that. It's very, very precise, and it's important that that be right. Okay, there will be a signature completing the transfer, just like you would have that on a negotiable instrument. And then there are a couple of types of deeds: a warranty deed, a quitclaim deed. And a warranty deed just basically it warrants the ownership And that goes through a legal process and a filing, and you're likely to have title insurance involved so that if something goes wrong with the title, then it's insured, and there's a way to recover whatever losses are involved. But then there's also something simple called a quitclaim deed. Has anybody ever heard of a quitclaim deed? Not a one, huh?
Yeah.
Okay. Well, this is just, it's just a real simple legal document that you use to transfer ownership. It does not have a warranty with it. It's just something that you do real quickly. And so the question is, why would you do that? Why would you ever have something that doesn't have a warranty? Well, there's a couple of reasons. One is to transfer property between family members or spouses. So it's not unusual, for instance, if I were to get married in my old age, not happening, folks. But if I were to get married, I might want to put my wife on the deed, and so I could quitclaim the deed from me to both of us as a joint tenant, joint ownership. So that would be one. Another one that's not unusual is in the case of a divorce, where one spouse will quitclaim the deed over to the other as part of the settlement, because you don't need a warranty in those cases. You know who the owner is. You may do it to transfer your property into a trust. And another one is, and this is interesting, is to remove defects on a title. Now, anybody want to take a guess as what might be a defect on a title? I could ask the one attorney that's in the meeting here.
And
Yeah.
she really wouldn't even be able to remember one because she
Oh, okay.
hasn't studied property since 1985.
All right. Well, here I am picking on you. Sorry about that.
I don't mind at all.
You could have a misspelling as an example, and it's those little things that can make the transfer of title when you really want to do it. It can make it difficult. So if you have a defect, like something that's misspelled, or an address that maybe is off one, or a lot number that's off one, or something, that you can refile that way, and that way your new deed is going to be correct. You'll hear quitclaim, every once in a while you'll hear that term. And all it should do is just trigger, okay, someone's doing a property transfer and they're just doing it the simple way. And that's not unusual at all. Sales contracts, I just want to mention that, how many of you have bought or sold a home?
I have.
So you've seen, yeah, you guys have seen the real estate contract. What did you think of it?
I don't remember the real estate contract. I ended up doing like a lease to own type thing. And then before my 4th year, it was kind of interesting actually. I had planned to do a 4-year plan to purchase the home. Nothing was going to change. Nothing was going to go through the banks. I kept on paying like weekly rent, and it was all going to go towards the final cost. And there was a power of attorney, which was the daughter of the owner of the house. And the owner had gotten sick, and in his will, they wanted to donate any properties he had to a church he went to. And what ended up happening is before my 4th year was up, he ended up passing away, and I had to meet to do the paperwork. Originally we had we had never done the actual paperwork, and I was kind of getting iffy about the whole situation. And then when I went to have this meeting, the church guy was there, the daughter, which was the power of attorney, the landlord that would come collect the rent, and I thought I was on punked because they had me sign over all the paperwork, and they just ended up giving me the house without having to pay the rest of that 4th year. Which I got the house less than what we had talked about, but I never actually had to go through like real estate or mortgage or anything. So a lot of that's still kind of unfamiliar to me.
Well, we'll give you something, Christina, you can look forward to.
I have a question though, because I did do a tax, I went to a tax auction, I can't talk today, and I bid on the empty lot next door, which I did win the bid on that, and I did get a deed for it, but I didn't know, like, so can I do stuff with that empty lot? Like, can I put a fence and make a nice yard? I don't know if I have rights to do anything with it, being that it was bought at a tax auction. I don't know.
Is there a recovery right for the person who was in arrears on the taxes?
There was, but I think that deadline was passed. I've had it for 2 years now.
Then the answer is yes, subject to zoning laws. So you may run into some things about where a fence can be on the edge of the property. And I don't know if you have properties that are together consecutively, if there are any restrictions for to prevent you from treating them as one, but I'm not aware of any. I have, where I live, I have neighbors who do have multiple lots, and they seem to just treat it all as one big yard.
Right, as one big yard. That's what, I have a neighbor that it's the same situation. I believe she owns about 3 lots, and I have 2 consecutive lots. So I figured, I could treat it as a yard, fence it out, but it was something I was needing to look into and make sure I did it the legal way.
Yeah, make sure, yeah, because you don't want to like put up a fence or something like that and have the city come out and tell you to take it down.
Right.
So yeah, you have to make sure that that you're not in violation of any zoning issues, but otherwise, yeah, charge ahead.
Nice.
Now, one of my first comment here about residential contracts. Remember everything I've told you about contracts, and you have to read every word. You do have to read every word of this too. But by and large, the states have real estate contract templates that exist to protect the people involved in the transaction. And they're not bad. It's not, you do a lot of sales contracts, and everything, the first contract you'll ever see as a customer is a contract that is all to the benefit of the seller. And you have to negotiate your way off of that. In this case, you're pretty much, when you're doing a real estate transaction, you're more likely to be negotiating the terms, the price, and so on, than you are picking apart the contract itself, because they are all pretty standard. Read it, make sure there's nothing in there that bothers you, but in general, you're not going to be changing much. However, you are going to have contingencies, because almost every sale of real property does. So what might be a contingency? Anybody who's bought a house, what would be a contingency on buying that house?
Passing inspections?
Yeah, that's a good one. It is not unusual to say it's contingent on passing an inspection within a finite amount of time. Do you want it in 7 days? When are you going to do it? So if you don't have if you say 7 days and you don't, and the 8th day rolls around, that contingency is expired, whether you had the inspection or not. What do you do? What do you do after the inspection? As long as you're throwing it out there, Everett, what do you do?
I guess I don't understand the question. What do I do with the inspections?
Yeah.
Just make sure everything's up to code.
Yeah, essentially, you're checking on the the unseen condition of the house. So the seller has a duty to disclose any hidden defects. That's required. If you've had flooding, if you've had, you know, if anything that you think might be wrong with the house, just because it's not in plain sight doesn't mean you don't have to disclose it as a seller. You do. However, you may have an inspector come in, and if anybody has ever watched an inspector work, it's pretty interesting. They do everything. They're going to run the water softener. They're going to run the heat. They're going to run the air conditioning. They're going to make sure everything works, everything that you would not observe. Now, the inspector's also going to note that the paint's peeling around the front door. And if somebody came back to me and said, well, the paint's peeling, you have to fix that because of the inspection, I'd tell them to go away. I'd tell them no. Now, would I let that stop a deal? No. If we were really going to draw the line in the sand, no, I would sell my house. I would get out the scraper, scrape the peeling paint, and paint over it. But the plain sight stuff isn't why you hire the inspector. You hire the inspector to make sure that there is nothing that you can't observe yourself. And that's really the role of that. What's another contingency that you might have? Anybody want to take a wild guess?
Guaranteeing the bank loans, all the loans have went through.
Yeah, so that's another contingency that you would have in your contract, and these are all addenda that you would have if you're working with a realtor, the realtor would write up for you. But it can be contingent on you obtaining the financing that you need to be able to buy the home. Okay, and not only is it to obtain the financing, but you will also specify the terms. So you will say, it is contingent on me being able to get a 30-year fixed rate mortgage at no more than 4.1%. Because if you get denied by the bank and someone says, well, this mortgage company will do it for you, but it's going to cost you 8%. If you didn't specify 4, but somebody can place you with, with financing, even if it's under bad terms, you're kind of stuck. Legally, you're kind of stuck. So you have to make sure you're specific about that as a buyer. And as a seller, I think you want your people to be specific too, because once the financing gets rocky, and once things are going wrong, it just means that the whole process through closing is likely to be bumpy too. And better to know right up front. Okay. So it doesn't matter whether you're a landlord who is buying properties and selling properties, or you fix up old homes and flip them, whatever business you want to be in, whether it's for, if you want to do it that way or whether it's personal, you need to know how this stuff works. And you get a good attorney, and your attorney will walk you through it. But you don't want to be in that position where your eyes just kind of glaze over as you look at things and listen to things and so on. And you just want to say, you have to take responsibility for your own transactions. Okay, we were going to get up to break here, but I'm going to fast forward here to Violet, and then we'll come back because that'll give us a little more time for exam review. So Violet, if you don't mind, I'm going to introduce you now. Everybody, Violet has spoken up a couple of times, but this is Dean Violet Hawkins, the Dean for Business, Supply Chain Management, and Information Technology here at the Ivy Tech South Bend Elkhart campus. You have to be really engaged and really nice because she's also my boss. But Violet got her bachelor's degree from Howard University. I assume it was a Bachelor of Arts, was I right? I was just going off of LinkedIn, Violet. Well, she'll be back. She also got her JD, Juris Doctor, from Howard University School of Law. She has worked as the Director of Fund Distribution for United Way Worldwide. Director of the Domestic Violence Division of Victim Services in New York City, Assistant District Attorney in New York County. I don't know if she's had a Law and Order episode named after her, but we'll ask her when she gets back. And she,
You know, you're very funny. I did have to call a student, you guys. I'm sorry. A student about something else, but do you know what's funny about the Law and Order thing?
yeah, what's up? Fire away.
When I was a DA for okay, I can't really see the students. Can you make it so I can see the students?
Do you see on my screen the participants? Okay.
Yeah, I got it. Okay. So anyway, when I was a prosecutor in Manhattan, and I was a prosecutor amongst 500, so let's not overstate the job. There were like 500
you were not Jack McCoy, is what you're saying.
No, I was not Jack McCoy. There were 500 of us, and the two things I would mention about that job would be that, one, this may not even be as meaningful to you guys, but John Kennedy Jr., do you all know who he is? You know who JFK was, the president, the first Catholic president? Okay, you know his son was a famous variety of things, famous lawyer, famous magazine publisher. Do you guys know who he is? Okay, doesn't matter.
I don't know.
He worked in my building, and I was in the elevator with him. Okay, that's just one small thing. But the thing about the Law and Order is the people that wrote that Law and Order program got the idea from my department. They were in our grand jury when they thought of this television series. How about that?
Yeah, that's pretty cool.
And in the grand jury is when, I think you can see it on Law and Order and every other TV show. Nowadays, everybody knows what happens. It's when you get charged with a crime, then the police arrest you and charge you with a crime, and then we take your case to the grand jury to see if the grand jury agrees that there was probable cause to believe you had committed a crime. And then if they say yes, which they almost always did, because hardly ever does a defendant go in and say anything. It's usually just us telling the story. So of course they hear our side of the story. And anyways, I just thought it was, and that was like a fabulous series, but it just was so ironic to me that the people were there. Well, they told us at the time, they said, this is really interesting. They just got called to jury duty. They were television writers though. This is so interesting. We think we might be able to make something out of it. And that's the last I saw of them. But then like maybe a year later, the series started and we recognized the fella's name who wrote it.
How many times do you watch a series like that and partway through you start going, no, they can't do that?
Well, so much of it. Now, Law and Order tries to be somewhat, what happens is you have to condense the story down so much that you can't make the whole story come out unless you operate in ways that are not really the kinds of legal things that you do. So most of the time you're saying, oh, come on, nobody's letting that go, or you can't say all that, or you can't do all that, but they have to condense it, so they have to make it work. But they do try to stay somewhat within the realm of, maybe. But it is fun to watch, and I still watch it actually over and over, really, I don't know, sentimental. But today, Kevin asked me to come talk to you and to talk to you about my experience when I was a lawyer for IBM. So when I was in law school, IBM recruited for me for our school, from my school, which was Howard University in Washington, D.C. And they recruited for lawyers, and they picked me, and then I got an internship. And it was really hard, and there are stories about that I could tell, but I won't because I don't want to spend all night. But I didn't really know what I was doing, and it was very frightening. And I was young and inexperienced and didn't really have a business background, because in law school you learn the law. I mean, you learn how to find the law and how to apply the law, but you don't really learn so much about business necessarily, at that time at least. But I survived it. And they offered me a job. So that was my first job out of law school. So in that job, I was just reflecting back, like, what did I do on that job? Mostly what I did as what they call an in-house counsel. And again, there were about, I would say there were 100 of us in-house counsel spread all over the country and maybe internationally. And what we did mostly was act like little law firms for the company, so that whatever went on inside the company, we were the lawyers who would handle the legal issues. But what we mostly dealt with, what mostly went on that required our intervention, who can guess what most of the problems were about? I see it. I see some, when the green box opens up, brightens up, does that mean somebody's going to speak? No, this isn't like Jeopardy or something. Okay.
It should be like that. I believe you're correct on that.
It should be like that. When your box lights up, you're trying to talk, right? So who can guess what most of the problems were that we dealt with, the lawyers dealt with? This is so you'll know. Just what are the problems in the real world outside of work?
I have a guess, but I want to hear it from the students. What do you guys think are the biggest legal issues, the biggest legal jeopardy?
Harassment.
Yes. The two biggest problems that we dealt with in our day-to-day work would be sexual harassment and discrimination, you know, based on gender, based on religion, based on whatever, based on ethnicity. So sexual harassment and discrimination based on what we call protected class status were our two biggest issues. So there was, and also drugs, because IBM is international, there were people who tried to use our internal mail system, because we had an internal mail system. There were people who tried to use that to transport drugs from state to state and overseas. You know, we had offices in Puerto Rico. We had offices all over the world. So they tried to use our internal mailing system to transport drugs. And so there were investigations about that, because typically they wouldn't be quiet enough about it, and somebody that they know would hear about it and say something about it, and then there'd be an investigation, and just like you would expect, they would be caught. And the sexual harassment and the discrimination based on gender, race, sexual orientation, although that wasn't as big back then, those happened a lot too, because people were always having inter-office inappropriate things go on. So we spent a lot of time on those. I got to go to Puerto Rico once for 10 days to investigate a race discrimination case. That was a fun trip and an interesting case. And so my territory was the East. I lived in New York, and my territory was the East Coast, which included with the Northeast Coast, but it included Puerto Rico for some reason. So, okay, so that's what we mostly did back then. And I was thinking, I wonder if times have changed at all.
Can I have $3?
Okay, I'm in class right now. This is my 8-year-old niece. She knows that I'm sitting here working, but she still needs $3. So
I need 2.
Actually. I can go ask mommy.
No, she's a bargain. Two's a bargain.
I know. My dog will be barking any minute now. So I thought, well, what's new in the business world? What's new in the legal cases that people are looking at? So I did a little research for this, and I tell you what, nothing much has changed. Most of the cases that they talk about online for businesses have to do with the same kinds of issues. The one thing that has changed from 20 years ago, what do you think that one thing is that's now an issue in business? It wasn't so 20 years ago. Even at IBM, it wasn't.
Internet.
That's a hint. Yes, internet. Social media. Social media cases are on the rise tremendously, as a matter of fact. Employment cases involving social media. So, okay, excuse me for one moment. My wallet is in my drawer there, but you need to not interrupt me. Okay, so I did some research that I thought you guys would be interested in. And Kevin, now it's 7:05. How much time can I spend? Because I could do this for about, an hour, but I know you don't want me to.
Well, we'll take a break at 7:30 or so, maybe a few minutes later. So I would say fire away, and because this is interesting stuff.
Okay, so here what I'm gonna do is give you guys some fact pattern. That's what we call them in law school. I'm gonna give you a case, and then you can tell me what you think happened. All right. So in this mostly male office, mostly men, these are recent cases too. They're really somewhat surprising. But anyway, in an office dominated by men, there was this game that they all played. And they called it CBT. Have you ever heard of that? C as in cat, B as in ball, T as in tap. Anybody heard of that?
Sound like something I would admit to if I had heard of it.
Okay, well here's what it is. It's casual. I hope you guys aren't too sensitive about this stuff, but these are legal issues in the workplace. It stands for casual ball tap. So what these guys are doing for fun is they are walking around the office and trying to catch you when you're not on guard and like taking their hand when they walk by you and tapping your private parts.
Played that in middle school.
Say it again.
I said we played that in middle school.
It really sounds childish, doesn't it? These are adult men. So these adult men are playing this really silly game. And it went on for a long time and nobody complained about it. And so they just thought it was super hysterical. Even the supervisor played this little game with them. But what happened? There was a downturn in business, so they needed to lay somebody off. So they decided to lay this one fellow off. And as soon as he got his termination papers, he said, "Oh, so you're firing me because I complained about that casual ball tap game. This is actually retaliation because I complained about a hostile work environment." Okay, now, there was an investigation, and in the investigation, what was found was the supervisor this fellow had not complained to the supervisor or anybody else in the company that they could find in writing or verbally. And he did have kind of weak performance. So of all the people there, he was kind of the weakest. He was the lowest producer, right? Okay, so nobody heard anything about his complaint, and he was a weak producer. What do you think happened in that case?
They thought that it was that there wasn't any like reason, like negative reason to why he got fired. He got fired with an honorable cause.
So you think that they found at the end of the day, there was a reason to fire him. He was a weak producer.
Yeah, right.
Okay, one might think that, but I'm going to add a couple more facts. They didn't have any written documentation of his poor performance. Does that change your mind?
A little bit, yes.
They didn't have a written policy that was clear about who goes when there's a layoff. And everybody admitted that they had been doing that behavior. So now what do you think happened?
I mean, legally. Oh, sorry, go ahead.
No, it's okay. You were first.
Well, legally, there isn't anything to prove that he was a weak performer or that he technically should be the one to go. But there is people admitting that they did play that game or that he didn't want to play that game or something around that does prove a little bit of his story. So now the company itself doesn't have like the grounds to prove that he was a weak performer or stated that if he didn't do as well, he would get fired first or anything like that. All there is that people admitted that they did play that game.
Precisely. Because they didn't have any good written policy, because they didn't have any real avenue for anybody to lodge a complaint safely, because they did admit that they all were doing that, they couldn't go to court with that because they didn't know that they would win. They didn't know if they would win or not. They didn't have a strong case because they had no good policies, no good written documentation of anything. They were all doing inappropriate behavior. And so he's saying that I complained to somebody. the weight of the evidence started to fall too heavily against them, and they settled. What do you think the lesson is from this case?
Document everything.
Exactly.
And put forth a policy for termination.
Exactly. And one last thing that's important. This is the most obvious one. Don't play games like that at the workplace.
And you can't allow it for a number of reasons. One is it's just not productive.
Exactly.
Second is, imagine, okay, so you have this going on. If you don't want to participate, do you feel like you have to go along to get along?
That's exactly
Are you
right.
putting that kind of stress on people? What do the women at the workplace think?
That's right.
I mean, you can go on and you start, as you start talking through it, all you're really doing there is you're making an incredibly toxic workplace.
That's right.
And it's not professional. Work can be fun. People can have fun and really enjoy working together, but
Exactly.
it doesn't have to cross the line.
Without the CBT game. Okay. All right. I have another one for you. And what the case notes on this one said was, even a weak sexual harassment case can give rise to a strong retaliation case. Nobody in that scenario could stand up and say, no way, I didn't see anything. Nothing went on here. He couldn't have complained about it because everybody was doing it and everybody knew about it. So they were in a really vulnerable position. Okay, here's another case. Oopsie. Oh, there you go. Okay, here's this case. Okay, let me just put this little aside. So when I went to Puerto Rico to investigate this discrimination case, it was the Black Puerto Ricans at IBM were saying that they could not get good jobs there and they couldn't get upward mobility on the job, et cetera. And the management there said that isn't true. So when I went down there, I went to the site, to the IBM office, and everyone in the office in any role that wasn't manual labor had white skin. And everyone who was doing manual labor on the dock was what?
Black.
Brown. Now, this doesn't mean they have race discrimination there, but the picture does make you pause and listen carefully and investigate hard. Okay, so now that's not the case though, but I think we probably settled that case. Although after I brought my investigation back, then I'm out the case. Then they decide on their own, the management level lawyers and the managers of the business, not the lawyers. The lawyers give advice, the business people decide. Okay, so here's another case. Okay, this lady, let's call her Sheila. She's attractive, appealing person. She works in the cafeteria. She kind of likes to flirt with the guys, and she does quite a bit of that. Sometimes she takes it too far. Does anybody know the movie When Harry Met Sally? No?
Oh, yeah.
No. Well, I know, me and Kevin do, but nobody else knows that movie When Harry Met Sally?
Come on, Everett. We count on you to chime in on these.
No,
I never watched it.
Okay, it's actually kind of a cute little romantic movie. But in one of the scenes, the lady in When Harry Met Sally sort of pretends to be involved in an intimate encounter, like noises and things. So this lady would even like do that for a laugh. She would just pretend to be doing something sexual and inappropriate for a laugh. So she was, kind of a big flirt and all that. Now, she was that at the job, but she also was not very good employee. She had attendance issues, and sometimes she had anger issues. The chef made her mad. She threw a plate of pasta down and broke it all over the floor, as well as getting pasta everywhere right in the middle of rush hour. So she had some anger problems, and she had the spotty attendance. So one day, she comes in at 6 o'clock, and her boss says, "You're late, Sheila." And she said, "I'm not late." He said, "You're supposed to be ready to work at 6 o'clock. It was like 6 o'clock. And she had her uniform in her arm, like she was going to go to the bathroom and change her clothes, or in the dressing room and change her clothes. So she said, I'm not late. And right there in the entryway to the restaurant, she changed her clothes right there in front of whoever was there to see it. Because she has anger issues, and I guess she was acting out awful bad. So she changed her clothes right there. And she said, see, it's still 6 o'clock. I'm not late. He said, yeah, you're not late, but you are fired, right? You might be on time, but you got to go. So, so she went to the Equal Employment Opportunity Commission, and she said they fired her as a pretext. They were just firing her because she complained about sexual harassment. Now, what do you think happened in that case? Now you're suspect because you know it's one of those tricks, but go ahead.
I think that the company won the battle because she changed her clothes in front of everybody. If it's a sexual harassment, that should have been from her to everybody else.
Okay, that could have happened. Anybody else have a thought? Okay, that could have happened, but it didn't happen. Because once she went to the Equal Employment Opportunity Commission and they investigated her complaint, they found lots of people that worked there who said that's a sexually charged atmosphere. I feel offended a lot of the time. It's hard to work here for that reason, but I have to keep this job. So she opened the door for the rest of her colleagues at that job to complain about the sexual harassment they were experiencing, even though she herself, they had a legitimate reason to get rid of her. But once that door was open, people walked through it and told the investigator how they felt about that job. So what ended up happening was the EEOC was going to bring a class action suit against them for creating a hostile work environment for their employees. And instead, that company had to settle. And I guess the settlement for amongst all the people that split it, it was like a 6-figure settlement, and all the wait staff there split that settlement. So even if you're right with the one person, if you aren't right, okay, so I'm telling you the answer to that. So what do you learn from this lesson, from this case? What are the lessons from this case?
Be consistent.
What? Say that again?
Be consistent.
Be consistent with how you treat people and treat them lawfully, which means no sexual harassment and no inappropriate comments and touching. And what else would you say?
When you open a can of worms, a whole bunch of creepy crawly things come out.
That's exactly what happened. So even though, in fact, what the article said was that employees who engage in sexualized behavior like this lady are often, well, disproportionately represented in the people who complain about sexual harassment. But the fact that she could behave that way on the job and no one did anything to stem that behavior shows you the environment she was working in. That her management team was not making a safe environment for people to work in. Okay, I'm gonna slip over because I just
before you run to the next one, if I could chime in, because I want to
Yes.
go back to the one fellow who said he didn't see a path forward for himself, and this is a case I do in principles of management all the time. So a few of the students in here might recognize it, but it's a larger case. But it's our company culture, and it has a lot of issues. One of the issues is the sales staff going out together once a month to a strip club. Is really bad, toxic cultural thing to do. And that's similar to the game, and I'm not going to get into that. But one of the things that the new HR director finds in the case is that somebody is leaving the company. He's a Hispanic man, and he's saying, because there is just no path forward at this company for a Hispanic man. And when you hear that, it could be extremely true. It could be totally true. It could also be a poor performer walking out the door and just complaining. And you need to be aware of that, though. And I'll give it a contrast. I pitched in for our workforce development people at a company in Elkhart, a warehousing company, which shall remain nameless. And they were doing a leadership program for their 9 top operations managers. And so I went in a couple times with them. And so I'd gotten to know them a little bit, and I was able to actually challenge them on this, because it was 9 white men. Now, as I said to them, you guys, every one of you is good at what you do. I can tell you're an impressive bunch. And I want whoever doesn't think you deserve the job you have, raise your hand. And of course, no hands went up, because they did. They had all worked hard and done it. But I said to them, now, do you have any women working at this company? Oh yeah, a lot. Got African Americans, Hispanics, and it's all a lot. So I'm telling you that they look at you all and say, there is no chance here for me. And so you need to be, does that cross you into a legal area of hostile workplace or discrimination? Probably not. It could get you there under the right circumstances, but probably not. But it still is a management issue. And all of the classes that you take from us in the business department are, when it gets right down to it, management classes. And it's really important to understand that you have to, when I talk to you about the enter their world concept, you have to turn yourself around and look at it from the world of the other people and see what's going on. And that almost makes it really easy, whether now you're starting to talk about stupid games or a culture with a lot of sexual harassment or any of those. Once you start putting yourself in the world of your employees and observing it with that eye, you're going to see a lot of stuff, and you're going to know to fix it.
That's right.
So you take this class, you get a lot of legal foundation for things that you should start recognizing, but it really gets down to you being a human being and a leader who is able to step in and observe these things and then take action about it. So
that's right.
Off of the soapbox here and back.
I like it though. I like it because the good management understands all those points that you were just making. That's what good managers know. Okay, I'm going to do a couple more things that have to do with technology, because for us senior citizens, technology is something that we handle with care, I think, more so than young people who grew up with it. So I'm going to give you guys a couple of cases that have to do with technology. One of them is called the imploding severance package, right? So when you leave a company at the end, if you're a big shot, you have a good deal and you're going to get a severance package. But usually the caveat is that's if you leave on your own, not for cause. Like you're leaving because it's time to move on, or maybe we just part ways because we just aren't seeing things eye to eye. But it's not because you did something bad for the company. So this particular man, he's aggressive, he's abrasive. He's the CEO of this particular company, and the board of directors wants to get rid of this guy bad. They want to get rid of him because he's awful to work with. But the agreement they have with this man is that so long as you don't leave for cause, we have a big $800,000 severance package for you. So long as you behave appropriately, as long as you do not display inappropriate behavior, do anything to embarrass the company, particularly if it's egregious. If you don't do any of those bad things, act unlawfully while you're representing the company. If you don't do any of those bad things, you're taking that $800,000 with you, even if we kick you out of here because we just don't like you. So the board is like, but we don't have any written documentation of anything, and we don't really have any good reason. We just can't stand this guy. So what do you think happened? I'll give you a hint. They did an investigation of this guy when he was gone on vacation. And where do you think they looked first to see if they could find something on him?
His computer.
You got it. His computer. They went through his computer records with a fine-tooth comb, and what did they find? Close. What did they find?
Porn.
Close. My sister's in the background. I tell you, my family is part of my coursework, right? What they found was, yes, pornographic conversations with one of their main vendors, one of the company's main vendors. They were talking back and forth on the computer about all the women that worked at the company and who they thought was would be great in certain, sexual circumstances, in great detail, very descriptive. So they had, and he had a lot of that kind of back and forth with this particular guy who obviously was his friend who was a vendor for the company. So the company lawyers made a copy of all those emails, put them in a little booklet. When he got back, they had the booklet on his desk with his termination letter. So he got a lawyer, but there was nothing that lawyer could do for him. So he left $800,000 on the table because he was reckless about how he was using his computer. How many of us have sent things on our computer that we wish we could call back? Just anything.
Yeah.
It doesn't have to be this horrible, but just things you wish you hadn't put into the world on your computer. That can happen so easily, and you have to be super vigilant about it. This is a true story, and it wasn't that long ago. I was gonna switch jobs. I was gonna go from one job to another job. I guess I won't say the jobs, but somebody sent me a note, and I thought I was writing back just to that person, and I wrote, "Hey girl, I'm leaving this job soon, and I just cannot wait to get out of here. Woo, it's gonna be a breath of fresh air when I walk out that door the last time." I wrote that, but who do you think that went to?
Everyone.
Like 20 people. Somehow I didn't see that was not her writing me. It was a group email. And so when I replied, it went to all of these people, including my employer. Okay, that's a lesson that I learned, and I'm so vigilant about it. But that is not a legal problem. That's just, I really kind of burnt that bridge slightly problem. And I didn't mean to, because it really wasn't anything. It's never good to burn a bridge. But back to technology for a minute. I want to share some statistics with you that I found when I was doing this research. Career Builder is like Indeed or one of these big job search sites that helps you create, your resume, et cetera, but also helps you find jobs. And they do a lot of surveying to find out what's happening in the work world. And one of the things they survey about is social media. And one of their more recent surveys showed 34% of those people surveyed, those employers surveyed, there were 2,300 employers surveyed. 34% of them said that they took negative action against an employee based on their social media posts. 34% of them said they took negative action against an employee that could be fired or, demoted or I suppose suspended. But 34% of them had taken negative action against one of their employees because of negative social media posts. 51% of the employers use social media sites to research their current employees to see what they're up to. 70% of these employers reported they used online information to vet candidates, meaning they're not hiring people that they think have a negative social media presence or a social media presence that's not in keeping with their mission or their goals and their brand, So now, having heard those stats, I'm going to go back and just give you a couple of little quick cases about it. Because people say, I have a right to say what I want to say. I have freedom of speech, don't we? We say that?
Nope.
Everyone
not
says
as it pertains to work.
Thank you. Who knows the First Amendment applies to what? If it doesn't, well, let me ask the question. Who knows what the First Amendment applies to? So we have freedom of speech, but in what context does the Constitution deal with that? This comes up a lot, and actually, even when I was reading this research, there were people who were non-lawyers who were talking about freedom of speech in a way that isn't really accurate.
And I know the answer to this, but if anybody else wants to take a shot, and if you've taken management class from me, you should remember this vividly.
This is a really good distinction for people to understand. Anybody? Okay, well, the First Amendment has to do with government action. The Constitution is written to protect us from government actions. So when we say the First Amendment protects our freedom of speech, that protection has to do with government making laws that impede our freedom of speech, or government taking actions that are impeding our freedom of speech. It doesn't apply to private employers. Private employers don't have to allow us to say anything we want to say, wherever we want to say it and whenever we want to say it. Even the Constitution doesn't allow, the government doesn't have to allow us to say and do anything, but we have broad rights to freedom of speech, freedom from government interference with our freedom of speech. So here's a couple of examples of how social media posts can get you fired, basically, no matter who you are. Everybody remembers how Roseanne Barr, maybe you remember this, now it's been a few years, I guess. Roseanne Barr, who used to be, she's a comedian that had a television show that was really popular. You guys know who she is?
Yeah.
Okay, Roseanne Barr. Okay, so do you remember when she tweeted this tweet? She tweeted a tweet that said, "The Muslim Brotherhood plus the Planet of the Apes had a baby, and that baby was this woman named Valerie Jarrett, who was on President Obama's cabinet, right?" She's a comedian, so I could see where she thought that was funny. And I could see where if she were doing her comedic thing on her own at a comedy club, some people would have laughed. Some people would have winced, like I might have said, "Ugh, that's a little much." But some people would have laughed and she'd have been fine. Because when you're standing up on a comedy stage, you're on your own doing your thing. And if people don't like it, they can leave or they can ask their money back. But when you are on a television show and you're working for a network, you don't get to just say any old thing you want to. And that's why she got fired from her own show. And the show is still on television, so it's pretty successful without her, which I guess the network is happy about that. But the point being, the network was embarrassed by what she said, and they must have a contract clause that says you cannot embarrass us or say things that are inappropriate or offensive to large groups of people. Whatever it says we can get rid of you because we don't agree with how the nature of your comments on social media. And it was just one tweet. And she tried to apologize, she withdrew it, etc. But they must have got so much flack for it that they couldn't take her back. Another example, and whether we all agree or not agree with her, the point is just the caution we must have with how we put our views out there and what kind of views we share with the world. A faculty from University of Tampa who didn't have tenure, he put a post out, the other side of the political spectrum. He said he put a post out that suggested the victims of Hurricane Harvey in Texas who drowned or died or lost their homes, that they were getting instant karma for voting for President Trump, for voting Republican. He got fired that day too, because the University of Tampa does not want people to work for them out there with aggressive, negative political statements that demean the value of human life, which is what the statement they viewed it as demeaning human life. One thing you can do and be fairly sure you won't be fired from your job, there's one category. If you disparage women or blacks or Latins or disabled people or people with sexual preferences, not heterosexual, if you demean people for those things, you're putting your job at risk because your employer may not want that to be a representative of the employer to have that view on social media. But You don't know. You might be able to get away with it, but you are in a risky area. One area that's not risky, I don't know if you talked about this, Kevin, but you know, the National Labor Relations Board protects certain kinds of speech even when we're dealing with private companies. Did you talk about that?
We did not get into this. Nope.
Okay. I'm not encouraging you to do this, but you are protected by a federal agency if you want to talk to your coworkers about how you view your employer. So if you're talking to your coworkers online or anywhere else, and you're saying, I think they're cheap, they don't pay enough, I don't like how their management team operates, whatever you want to say, they all got raises and we didn't get anything, it's not right. Those things, that kind of speech is protected. Basic speech about the terms and conditions of your employment. So those things are protected. And sometimes the states have protection for you, but you don't know what the specific protections are if you don't do the research. And I would suspect that Indiana doesn't have a bunch of protections for employees around free speech. And I think, here's a little thoughts about social media and your employer. If you're making a statement that has any possibility of being provocative and you just feel compelled to make the statement, you can say, this is my individual statement. It doesn't represent anybody's view but mine. This is what this is what I believe. You should never share in any way public proprietary information from your employer, like things that your employer trade secrets, you know, copyrighted material that hasn't been approved for sharing. You should never share any of the valuable assets in your company online. And you shouldn't harass, I don't even think I need to say it, but you shouldn't harass or bully or attack people, individually attack people online. All of those things could cause you problems on the job. So I really want to say that about social media. And then there are a lot of things. The fact that 70% of the employers look online to see what kind of person they're dealing with before they hire or don't hire you is, I think, that's the bottom line right there. Are you representing yourself in social media in a way that is presentable enough that it will not get in the way of you getting a job? Are you saying things that are presentable enough that they won't get in the way of you getting a job? The other thing I read also was, on the one hand, you need to have a presence that's reasonable. But on the other hand, you do have to have a presence, because if you don't have a presence, they're suspect of that too. Because it's it's everyone. It's what's that word, Kevin?
Ambiguous?
No. I never can remember this word.
Well, I'm thinking it's because, you know, it looks like you've gone underground and something's suspicious here. Who
well, that's true. That's true. That wasn't the point I was making. I was making that point, but I had another point. I was making the point that everyone is on social media. So if you're not there, yes, you're underground. There's a word that's everywhere. It's a word that means everywhere.
Oh, ubiquitous?
Ubiquitous. Thank you. I never can remember that word. It's social media is ubiquitous. So if you're not there, that's a red flag. So you want to have a presence, but you want it to be respectable. And I will end with this. My social media presence is like super lame. I'm on that LinkedIn. I haven't updated it lately. It's nothing special. I don't go over there and put anything except it just has like a resume type situation. The president of the college, I told this to Kevin, I was so embarrassed. The president of the college went and looked at my social media page and sent me a request to, I don't know, what do you?
To connect?
Connect, yeah. I was so embarrassed because she sees that I'm not sophisticated or on top of my game professionally enough to have a really strong LinkedIn page and a good social media presence. My presence isn't horrible or anything. It's just very lackluster and plain. So I say that to say, I'm preaching something that I don't follow myself, but I want to do better with it because it is really important. People do look at your social media presence. It could mean a job or no job. And for all of you budding professionals or professionals on the rise, you don't want to put an impediment in your way that you could avoid really easily. So that was all that I wanted to say, and I'm 10 minutes over, but did you guys have any questions or thoughts about social media or just employment law?
I just wanted to share that for a lot of scholarship applications or opportunities, they also ask for your platforms and social media because they do check it. And it's
That's
very
right.
normal.
And it is, and more people, like, because many managers are older, we're not as quick to go check on somebody's, we're not quick to Google. I am quick to Google now, but initially I wasn't really quick to Google. But one of my colleagues a while ago in some job that I had, which will go unstated, he wanted a full-time job. He was a part-time employee, but when they went to look at his social media, they found out, this is the other thing, it wasn't even a social media. If they Google you, they're going to see your whole life. So they Googled him and they saw that he had lost his medical license because he was a drug addict. So everything you do, you have to really think about the implications of the internet. So he didn't get the job because he, first of all, didn't say anything about it in the interview, and he didn't. That's something you might want to head off. Don't wait till they Google you. You explain that up front, how you ended up having this drug habit, and make it sound really sad and that you've overcome it. So they're going to Google you. They're going to look at your social media, make sure. And if it's not the best right now, just work toward cleaning it up and put a bunch of good stuff on there and try to get rid of what's not so great, so that your history is going to be a long one of good things versus some little remote thing that happened in the past. Yes, Kevin?
Yeah, I just want to throw out a couple of other things too that just triggered off of what you mentioned, Violet. One is I have, in my IT days, been responsible for doing investigations. I have investigated senior level managers for price fixing activities. I have investigated countless sexual harassment cases, inappropriate comment cases. I have had to investigate frauds. And I am telling you that if you use email, chat, or anything else, it's all there.
Yeah.
I've also worked with attorneys who, when cases were going to court, where we have to, give the outside representatives access to our email archives and work with them on keywords. And you know what? The more you do it, the better you get at it. And I can tell you that if you just give me a half a day, you can't hide from me.
Yeah.
You have that. And so it's really important that you understand that, and you have to keep that firewall up between work and personal. It's just really important that you do that. There may not be anything embarrassing at all in your personal messaging as well, but it's nobody else's business. So you leave it at that. The second one is you mentioned trade secrets. And again, and I say this, this all kind of ties together, because whether you're a management professional, a business professional, an IT professional, or whatever, and I used to tell my IT guys all the time, you are going to see all kinds of information that is for your eyes only, for our eyes only. It's the access that you get in the IT world to what's going on in a company is substantial. And so one leak in my world was always a firing offense. You didn't have that coming. And I can tell you, I take it seriously enough that I go back into the 1980s when I signed a non-disclosure agreement, because I took over the corporate systems function at a large insurance company, and the investment system had some proprietary stuff in it that they used to so that their investment portfolio could outperform the markets. And it was a couple of weeks before they got together my non-disclosure, where even the people who reported to me couldn't tell me what they were doing. But other than to say I signed a non-disclosure agreement about something, I haven't told a soul about it. Not a family member, not anybody. This is what the level of reliability that you need as professional people. And when you have that kind of reliability and that kind of trust in your businesses, then you are going to be all the more valuable. You're not going to be the person that walks the company into a legal situation.
And that's the other thing, and I'll end on that. If you file suit, if you get sued, that's all discoverable online. because litigation material to a large extent is public documentation that anybody can get a hold of if they give it long enough to get published, or if they know how to route into it. Most lawyers can get into almost any case file they need to look at, or any case summary they need to look at, or any court ruling they need to look at. But even we can Google and find these things. So before you take action against somebody or do anything that would cause them to take action against you, think about the ramifications of that long term. It's so much better if you think, oh, I don't know if I should do this. Don't do it. You're way better off being extra cautious than being cavalier. And I have a few stories of those cavalier moments in my life that I'm just lucky that I didn't really suffer a career damage because of it, because I just wasn't taking my professional life seriously enough. Luckily, there was no Google. That's the last thing I want to say. Caution. Kevin, thank you for having me.
Oh, thank you so
class,
much
for your
coming in.
attention.
Thank
I
you so
enjoyed
much.
Thank you.
thinking about those cases. I miss being a lawyer every now and then.
Thank you.
Really, when it's fun to do this work. So thank you, everybody. Have a great break, because you're almost at break point.
Yeah,
Enjoy
but
your break.
everybody's going to enroll in the summer.
That'll be good. They'll still get a couple of weeks off, and then they'll be refreshed and ready to go. All right. Bye, everybody.
Bye.
Bye.
Bye, thank you.
Thank you.
All right, let's take a break. We can go, I'm going to go back up here to my little break icon because that's where we left off. And it is right now, it's 7:47. So let's come back at 7:55. 7:55. Oops. There we are. So I'm going to do this before I forget. And we're back. So tell me you can still hear me.
Yes, I can still hear you.
Okay, because yeah, I'm getting an alert on my microphone, but it doesn't seem to have stopped. So we'll press on. If anything freezes up, I'll reconnect.
Okay.
Okay. We start with grammar fun. This is the about being concise. That concise is good, but clear is even better. So it's nice to save the space on that third sign, but I don't know what dancing sandwiches are. This also is important to be clear. All girls with long hair must be tied up.
Oh no.
Now we got to work on clarity for that one. And we got to work on clarity here too. Well, I guess this is actually pretty clear. Sorry, I was sipping on my tea. Then we have, this is the don't say part, that did you know that dying is the leading cause of deaths in South Africa? And did you know that the ingredients in this package are carrots?
Nice.
Yeah. And this is about Princess Diana. Did you know she was alive? She was still alive hours before she died?
You would think so.
You don't say. This one, not an exit. You don't say. Bugs flying around with wings are flying bugs. You don't say. Federal agents raid a gun shop. Find weapons.
Love that one. That one's my favorite.
Homicide victims rarely talk to the police.
Yeah, I think.
Hardly ever. And bad times, just times that are bad. And guess what? Where? Pizza Hut. We have pizza. Yeah, wet floor. No kidding. You don't say. This one, yeah, birthdays are good for your health. Studies have shown that people who have more birthdays live the longest. You don't say. Here. What has 4 letters, sometimes has 9 letters, but never has 5 letters? Who has that one yet? Who's gotten it?
So what has 4 letters, sometimes has 9, and never has 5?
Yep. No question mark, so it's just a statement. Good job, Leslie. And this is just a final truth for all this grammar stuff, and that's you're never too important to be nice to people. Oh yeah, but it's not the final truth. Actually, I saw this, so I threw it in there. This is good coronavirus humor. So I don't know if you can think of.
Oh gosh, I laughed too much at this.
Yeah, I like System of a Lockdown. I like Wuhan Clan. And of course the flu fighters and Miley virus. That's pretty good too. Okay. So Fair Credit Reporting Act. I didn't put my pictures in here. I went and found all these pictures. I forgot to put them in here. So you're going to have to go without the pictures. Okay. We're going to talk just for a minute about the Fair Credit Reporting Act. There's plenty of information about it in the book, and it's good to know. This is a 1970 federal law that regulates the collection of credit information and access to credit reports. It was intended to make fairness, accuracy, and privacy. So before 1970, you didn't necessarily have the ability to get to your credit report, nor did you necessarily have the ability to correct anything that was wrong on your credit report. So this was kind of important. It was important consumer legislation. So businesses check credit reports for many purposes: loan evaluations, selling insurance, anything else you can think of? We're just talking about it a little bit.
Buying a house.
Certainly buying a house, yep. Sometimes you get it for employment too. You know, banks notoriously, they want to know if you're in credit trouble. They don't necessarily want you in the vault. This gives consumers some rights, including free access to their own reports. So you do now have a right to get your own credit report, which is kind of nice. So the consumer rights are these, and these are the big ones. One is we get to verify the accuracy of our reports, especially when they're required for employment purposes. The second one is you get a notification if a file's been used against you when applying for credit. So if you go to apply for that mortgage loan when you're buying a house and they turn you down because of your credit report, they have to disclose that, because that gives you the opportunity to say, really? I don't think there's anything bad in there. Let me see. You go pull the credit report, and you find out that there is something that's there that doesn't belong there. And as a result, you can have that fixed. It takes a little bit of work, but you can have that repaired, and then you can go back and reapply for credit. You can, so that's the dispute process that you have. And you can also have outdated information, negative information. You know, it's like after 7 years in most cases and 10 in the case of a bankruptcy. So you can do that. You can get things fixed. You can also demand that they fix things. For example, several years ago, I sent my mortgage check in via the mail like I always did back in those days. Now I just, you know, I do it automatically, but I did it via the mail, and I sent it in, and everything was fine. I sent it in, you know, beginning of the month, right near the first of the month, and they should have had it. And then it turns out at the end of the month, they called me and they said, "You haven't paid yet this month." And I said, "Oh my goodness. So what are we going to do here?" Well, but the problem was it was past 30 days, and now they were giving me a late report. Several weeks later, I got another call, and they said they found a whole stack of old unprocessed checks. What should they do with mine? Because they lost it. And I said, well, you should do two things. One is you should tear it up. And number two is you should go fix my credit report, which they did. So that was a good thing. So you have those rights. So I wanted to use that as a backdrop for discussing this case. So let's just start into it, and I'll read a little bit, and then we'll talk. So it's this fellow, Keith Santangelo. He contacted Comcast Corporation through its online customer service chat function. Now, how many of you know what a great customer service organization Comcast is?
Yeah, okay.
Have any of you ever met someone who said, boy, those Comcast customer service people are really good?
Their wait times are really good.
My favorite was because I was a Comcast fiber company at my last customer at my last job. We bought, you know, fiber and telephone, you know, a whole bundle of services from them. And they used to give you this special number for businesses to call when, you know, if you had some kind of line trouble or anything like that. And so we were able to call the business hotline number, and it would tell you, it would answer like this. The recording would say, "You've reached the Comcast business hotline. Enter 1 if you're a residential customer and 2 if you're a business customer." Excuse me. So yeah, it was well done. Anyway, so during the chat session, he wanted to get internet service in his new apartment. And during that session, the representative asked him for permission to run a credit inquiry. He asked if there was an option to avoid the credit inquiry. So the representative told him, yeah, just give us a $50 deposit, and then we don't have to bother with the credit. So that was the option that Santangelo chose. He didn't want it, and it was part of Comcast policy, so he went with the $50 downstroke for it. When he made that choice, Comcast, without his permission, still pulled his credit report. And this unauthorized inquiry lowered Santangelo's credit score. Do you all understand how that works?
Yeah.
Okay. Credit inquiries, if you are constantly doing credit inquiries, that's going to lower your credit score because they think you're always shopping for credit, always in need of credit. It's a red flag type of thing. You know, look, you apply for a credit card or something like that, you're going to have an inquiry, but you don't want a bunch of inquiries that you don't need, and you certainly don't want to be out applying for credit cards every month. So anyway, this unauthorized credit inquiry lowered his score. Santangelo filed a complaint alleging that Comcast actions violated the Fair Credit Reporting Act as well as Illinois state law. Comcast filed a motion to dismiss, arguing that he had not stated a claim under the FCRA. So can a company violate that by running a credit check on a customer who's paid a cash deposit in lieu of a credit inquiry?
No.
No, that should be an easy one. So the decision was the the district court held that Santangelo's complaint sufficiently alleged facts showing that Comcast had obtained his credit report without a permissible purpose in violation of the Federal Credit Reporting Act. Therefore, the court denied Comcast's motion to dismiss. And what they're really saying is you don't have a right to do that, Comcast. So, questions? Do you agree or disagree with the decision that was made by the courts?
Agree.
Why might Comcast think it ought to run a credit report anyway? I'm not asking whether they're right or wrong in this question, but why might they think that there's a legitimate business reason for it?
So that they can ensure that they'll be paid for their service that they provide.
Yeah, I think that, that's what it is. And perhaps they saw it as a red flag that the guy said, I don't want you to run a credit report. I'll just pay the 50. And now they're saying, oh, this guy's probably got bad credit. That may not have been the case, but that may be what their reaction is. So, look, it could be that the customer service rep was just nosy. It could, there could be a lot of bad explanations for this, but it may be unintentionally bad in that somebody is saying, hey, this might be a risk customer. Maybe we need to flag this customer and not go very far with him if he gets past due. Because you can, as you all know, if you're a Comcast customer, you can rack up a big bill in a short period of time. So that, that's what you have, especially with the on-demand types of services that you have. It's real easy to start doing a lot of pay-per-view. Nevertheless, it's against the law, and you need to understand that. What should Comcast do to mitigate issues like this? So this is the management part of this. What do you do? Who haven't we heard from today? Let me hear from Monse. You still here? Yeah, you're still here.
Yes.
What would you do? What would you do to keep your people from running credit checks that they shouldn't?
I would look to see, like, if I was Comcast, I would see, like, if they're constantly, like, being late with their bills and stuff, or, like, they're not having money in their bank account when they have, like, automatic or stuff like that. I would give them a final notice and, like, let them know, or, like, come with a term agreement, like, after so many times of, like, having to wait for the payment, like, you're not gonna have an option or something like that.
Okay, so where you're going with this, let me try and rephrase it and see if I'm on seeing if I understand what you're saying, is from Comcast standpoint, they can have a business practice that says we don't create a lot of exposure for ourselves. We don't get in a situation where somebody can get 2-3 months past due on us. We kind of nip it in the bud. Is that where you're going?
Yeah, sort of.
All right. So I think that's part of the equation. You have to have solid policies that keep you from being exposed. What else can Comcast do to make this to deal with the issue of people either feeling the need or just capriciously going and trying to run credit reports? So I don't know, Lachey, you got a thought on that? Don't think so. Okay, let's keep moving. So, maybe Brandy, you got something on this you want to say?
I'm not really sure. I mean, do you mean as far as what to do to
Yeah, let's
mediate
just
it?
say you're the customer service manager. So what are you going to do to keep your people from running credit reports that they shouldn't run?
Yeah, I think I'd do the same thing, really. I'm not sure what else there would be to do other than to start putting out final notices. And
Okay, so
yeah.
I think yeah, and I'm going to jump in here. I think you attack it from that direction too, is one. And I know this as a banker, and I was responsible for the overdraft policy for my bank. I wrote the whole thing because something that sort of the dirty little secret about banks is that the most profitable individual customers they have are ones who have checking accounts, and they overdraw them on a fairly regular basis, not all the time, but they overdraw and they pay you back because overdraft fees are outrageous. And so, if somebody overdraws, and so you build your policies around that. And so, for example, if you're getting a payroll direct deposit and you get one every 2 weeks, and now it's Wednesday, and I see that Friday is payroll day, I'm not going to bounce your check. I'll pay it. I just did you a big favor. I'm going to charge you through the nose for it, and but I know I'm going to get the money back on Friday. So that's how you start to look at risk in these situations where you have customers who can owe you money. Now, from the same standpoint, you don't want to be in legal jeopardy. And as Violet indicated in one of her cases, you don't want this stuff to turn into class action cases, because then you're paying everybody. You're not just taking care of Keith Santangelo. Now you're starting to say, I have 100,000 people who might be aggrieved. And that's a different problem. So it's really important. You think of a standard customer service job. You're just answering the phone, doing chats and things like that. And we tend not to think of those jobs as having a lot of business law knowledge. But in this case, if you're going to be opening new accounts, then you darn well better know what the Fair Credit Reporting Act is, and you better know the things that you can and cannot do as a result of that act. And I think that's really that's what the important takeaway for this is. You really have to train people. I mean, you all are taking this class, and I'll have some summary comments at the end, but you're developing a sense of what should worry you and what shouldn't. And we sure, in the course of 8 weeks, and especially in the hybrid format, we can't cover everything. But if I accomplish nothing else, I would like to have at least given you kind of this meter that goes off every time that you sense a situation that could have legal implications. And that's really what what a manager has to do, so that you know what to train your people to do, and not just don't run a credit report when somebody asks, but why? Why can't you do that? What kind of jeopardy do you create for the company when you do that? That makes it so much easier for people to absorb it if they understand the why. So any other questions or thoughts about this case?
No.
Okay, well, let's move on then. The next thing I want to do here is we're going to go back into real estate a little bit, but this time as landlords and renters, because some of you may find yourself in this situation at some point in time, whether you work for a property manager, whether you buy property yourself to rent out to others, and certainly as renters ourselves. It's important to know that renters have rights and renters have responsibilities. So the rights, you're almost going to look at some of these things and say, duh, of course, but you have a right to running water, a sink, a stove, and an oven. And a refrigerator isn't required for rentals. But if they give you one, then it better work. So your landlord, or when they say, or your agent, you might, it might be a corporate and a corporation who hires a property manager or something like that. So that would be the agent. May only enter your apartment to inspect it, make repairs, or show the apartment to prospective tenants. Unless there's an emergency, they have to give you notice. So you have to be, you should be wary of that, but you can't just, as a landlord, you can't just go in to snoop. Hey, they're gone. They went to work for the day. I'm going to go in and see what's going on in there. You can't do that. You may think, hey, I own it. I have a right to inspect, but you don't without working with your tenants. Landlord can't terminate tenancy or raise the rent in response to you exercising any of your legal rights. So in other words, if you go and say the paint's peeling or the stove doesn't work or something, the landlord can't respond by raising your rent or kicking you out or anything like that and saying you're a pain in the neck. If they're taken with 6 months of you contacting the services department, the appropriate department in your state, then or if you just join an activist group, a bunch of tenants who want to band together and file a complaint, then that would be considered retaliation. You can't do that either. And then the landlord has to do the best to keep apartments rodent and insect free, which means it's not unusual for landlords, especially in large apartment complexes, to come through and spray for roaches and spray for ants and all that kind of stuff on a regular basis. As a renter, you got to pay on time, or you may be subject to late fees, and you can be evicted if you get too late. It says here, never pay rent in cash, only by check or electronic funds transfer. And I think that's pretty good advice. But if you were to pay in cash, when I was in college, I waited tables. So I always had cash. And not only was I paying my landlord in cash, I was paying my landlord in a lot of 5s and 1s. But I always got a receipt. So at least you want to get a written receipt. Certainly follow the terms of your lease. And when you move in, this is important, you want to make note of and take pictures of anything that's damaged when you get there. You don't want to be held responsible for damages that existed before you arrived. And it's also important you take that to your landlord and say, hey, I'd like you to fix this. So you want to do that. You need to dispose of garbage and recyclables and all that. It's got, you have to do that. You can't just let it pile up in the place. Some people do, but you can't. And you have to behave responsibly on the property. And we'll get into that a little bit more in a minute. So the landlord's obligations, the landlord actually is required to keep the security deposit secure. In other words, you can't go spend it and then, you get to the end and say, I'm kind of tapped out. I spent your security deposit when you're ready to move out. I'll get it to you next week. You can't do that. Security deposit should go into an escrow account. You have to disclose the owner. So you may be an agent, you may be a property manager, but you have to tell the tenants who the owner is, whether it's an owning corporation or a person, it doesn't matter. It could even be a trust, but there has to be somebody that the tenant can contact if necessary. Of course, you have to deliver possession of the unit as promised. So you sign a lease that says you get it effective June 1st, then it better be ready for you June 1st. You have to maintain it. You have to provide maintenance, and there's also liability issues. So you got to do things like clean up the ice. Best efforts to keep the walkways free of ice and everything else. And certainly you cannot have a breaker box wired up like the one on the picture. That creates liability as well. And when that starts a fire, those liabilities can be extraordinarily severe. As a renter, you have to adhere to the lease agreement. We mentioned that before. You have to maintain the premises. You can't let it get garbaged up like this. You have to do what would be reasonable cleaning and maintenance of the place yourself, and you do have to allow the landlord to enter the premises. Now, the terms of that should be spelled out in the lease. And that looks like this. I'll come back to the other page in a second. But this I thought was pretty good. I went and I was out looking for something that was pretty good, because some leases will say that the landlord doesn't have to give you much notice. Some try to get away with saying the landlord doesn't have to give any notice, but that's not legal. But they might tell you something like 2 hours or something, and that can be darned inconvenient for you. So you don't want that either. No, this is the no notice if you abandon the premises, or if there's an emergency, there's a grease fire or something in the kitchen, landlord can go in there. And you can go in if you've been requested to make repairs. So the answer can be, okay, I am going to go in and I'm going to replace that bad refrigerator while you're gone. So those kinds of things are okay. But now this one, what I liked is it said 24 hours notice. This is to carry out repairs that you requested. This says that a landlord or an agent can carry out, gets into the repairs. But this is the other one, the desire to enter to show the premises to a prospective purchaser or mortgagee. So, you may be trying to sell the apartment building or a rental home or whatever. And if you have somebody who's going to buy it or someone who's going to do a mortgage on it, then they're going to want to see it. They're going to want to do an inspection, and you can't stand in the way of that just because you're the renter. And then this one has 7 days, if they want to come in and redecorate. They say, I'm going to come in and paint. I'm giving you 7 days notice. I'm going to come in and paint the living room. So those kinds of things become part of it. And I thought that was pretty solid, and that's the kind of thing that you should be looking to get. Just a couple of things on maintaining the premises. You certainly have to follow building and housing codes, keep the unit safe and sanitary. So yes, you do have to clean up. You have to get rid of the garbage. Maintaining plumbing fixtures, it doesn't mean you have to do all the plumbing repairs. In fact, you probably don't. That's really the landlord's issue. But you certainly have to keep them kind of clean, and if they start to get build up of iron or anything like that, to make sure that you take care of that as well. Just all the normal routine things that you would do in your own home. You want to properly operate everything, so you don't overload circuits. You don't, all of the kinds of dumb things that people do that can cause damage to a building. You just can't do that. Your responsibility as a tenant is, no, I don't have to use enough splitters that I have 13 things plugged into this outlet here. And you have to maintain the appliances. What does that mean? It means, you clean out the lint filter on the dryer if there's a washer and dryer. It means you clean the stove once in a while, those kinds of things. You can't do damage to the unit. You have to respect neighbors' peace and quiet. You can be evicted if you are constantly throwing parties and keeping everybody else up at night. What would you do if you're going to throw a party? What's the right thing to do with your neighbors if you really do plan to throw a party in an apartment building?
Let them know ahead of time. Or
let them know ahead of time. Even better, there's something you can do.
Invite them.
Invite them. Yeah. Can't do illegal things. Can't mess with the smoke detectors or the CO detectors. And don't disturb paint in homes built before 1978. Why? Who knows?
Lead,
yes. So yeah, you don't, you may decide you want to paint, but don't scrape it down to the to the bare wood, because you may be creating a different kind of issue. You also have to prevent mold growth. So, what does that really mean? It means don't let mold fester. If you start to see it, you notify the landlord right away and have it remediated, because that can be a real problem. And sometimes mold is an indicator of something else going on. It could be, for example, some leaking pipes in the wall that create a persistent dampness that winds up turning into mold. So it's really important to to deal with those. Rule of thumb: deal with the place like it's your own. Okay, home stretch. Exam review. Number one, announcement on the exam. I took off all the timing stuff, so you got as much time as you need to do it. Both sections. In the long answer part, be ready to discuss the legal forms of businesses, including why you might do them for tax treatment, how survivorship works, how is it passed on, what happens if for instance, in a partnership, if one of the partners dies, those kinds of things. So be prepared just to to discuss that. Again, you don't have, it's only 30 points, so you don't have to give extraordinarily long answers. Just give short, thorough answers. Be ready to discuss laws that keeps products safe, especially related to food and cosmetics. So, we didn't spend a lot of time in the classroom, in the virtual classroom here, on product safety, but there's good material in the textbook about it, and just be ready for that. Be able to talk about the difference between real and personal property. What did I say? The contrast between real and unreal, or is it maybe real and surreal? I'm not sure, but yeah, real property and personal property. What's the difference, and why do you think there's a difference? Anybody want to speculate on that? As a consumer, what's really important about real estate? You all still with me?
Yes.
Is it how it's being used, treated?
You're on the right track, I think, of the how it's being used, but let's go a little bit farther. What, when someone buys a house, what?
Yeah, to disclose everything going on, like the contingency that you were talking about earlier.
Yeah. But here's what I'm fishing for, and this is really important to understand when you start thinking about real estate law. When an individual buys a home, it is generally the biggest investment somebody is going to make. Unless you're just a really, really rich person who is, owning companies and things like that. If you're Warren Buffett, then your home is not your biggest investment. But if you're me, then the home is where you have more of your assets committed than any place else. And so losing the home for whatever reason, whether it's because of a fraudulent sale that doesn't disclose a problem, or whether it is some other financial related reason, it is a tragedy. It is a tragedy for the person involved because so much money goes into a home. And so real estate law is built to be extra protective of people when it comes to real estate, to their properties. And it's really, really important to understand it. It's important to understand that as in lending law as well. So people, it doesn't mean you can't lose your property, but it makes it harder for for the bank to foreclose, or for someone to have to make a fraudulent sale or whatever. It's built to protect individuals because a deal gone bad, a home gone bad, is going to be financially crippling for most people. Okay, be conversant in employment law, and I think Violet gave us some really good stuff, but especially as it pertains to discrimination. And this is really important to understand anyway. It's, you know, when you get into the world of work, what are protected classes? Especially be kind to old people, and identify the different kinds of discrimination that people can encounter. And I want you to walk away from this class with a real appreciation for what those things are, because you know, it's, you just don't want to, you don't want to get yourself, you don't want to get your business in trouble. So as I said earlier, if you can, you know, if you can start looking at things from the point of view of others, it's, you know, and you start doing that because you understand what a protected class is and why that class of people, whether it be older, whether it be, you know, racial, whether it be religious, whether it be sexual preference, it doesn't matter. But once you start, you know, putting yourself in the other person's shoes, you can sort of see why just even even an uncomfortable workplace can feel extraordinarily overbearing to another person. Something that makes you cringe is just, you know, overbearingly discriminatory to someone else. And I think that's important to understand. Negotiable instruments. Yeah, remember negotiable instruments. Is this example right here a negotiable instrument?
Yes.
It is not.
Oh, sorry.
You can cash in on the thanks, I suppose, but yeah, you know, we'd make people just say a million times, here, go, start. Anyway, you know the components, understand what security interest is in it, and you know, a little bit about, you know, how banks must deal with fraud. And remember, you're not going to be on the clock on this test. So if you prepare, you will be able to easily find some of this stuff as you need it. So you'll be good at reference. And you know, that's a good thing. If you can walk away with this with the ability to find what you need, I think that's good. Understand bankruptcy. What are the goals of the bankruptcy code? What's the difference between Chapter 7 and Chapter 11? But you know, the important thing in bankruptcy is what, go back to these goals, because there's really two things that are going to happen in bankruptcy. One of them is that you're going to liquidate the company because it's just not viable anymore. But the other one is you're just going to reorganize. You're going to reorganize your debt, and you're probably going to do some things to change the way you do business. And in doing so, you're going to buy yourself some time to right the ship. And that's really, you know, that's how Chapter 11 works, and it's a really, really valuable tool. So a lot of small businesses have to go through bankruptcy, and they come back stronger, and they can thrive after that. Know a little bit about UCC2 and sales agreements. We talked about that, and you remember when Brian Kubicki came in and talked about that. But you know what happens when someone fails to deliver product or completes work. You know how agents work, understand financing agreements and liens. And I put over here a little job brief for purchasing manager. This is one of the really great careers in business, is being in purchasing, especially if you like working with people. You know, you have to be knowledgeable. You're going to have to do a lot of negotiating, but you're also going to develop relationships with suppliers that are really productive, and what you do is really important to your business. So if you know, understanding the commercial code, understanding how sales agreements work is really, really an important part of being in the purchasing field. And there isn't a one of you that I couldn't imagine being successful in that role if that was what you chose to do. Employment, we talked a little bit about employment before. Understand interviews and screening tests that people do. You know, if you go to work for a bank, for example, and you're going to want a job as a teller, they're probably going to put you through a test after they do the first interview. And if they like you, they're going to, you know, test your ability to operate a computer, to do some research, some of those kinds of things. You know, what's the legality? Where do they cross the line? Understand ADA. Americans with Disability Act is really, really important. It is just too easy for some people to say, I see that, it's a problem, I can't hire this individual. And you're doing two things there. You're doing two really bad things. One is you may be setting yourself up for a lawsuit, and that's bad. But even worse is you may be eliminating some incredibly talented people. I mean, put yourself in the other shoes. Say you're dealing with a disability, and it doesn't, you know, you can pick one. It doesn't matter what it is. You have to navigate life anyway. And if you do, you're overcoming. That tells me that you're brilliant and you're persistent. And why would you turn away somebody that has those attributes? So you want to create, do it because it's going to keep you out of legal trouble, but do it because it's really smart, really good business. Be right with people. Same thing with the Civil Rights Act. You don't want to get sued. You don't want discrimination suits, but darn, I just want to hire the best people. Give me people that, if I can consistently hire in the top 25% of people, I can rule the world. And I think that's what's really important. Also, no hostile workplace. We talked about that a minute ago. Keep your antenna up for that. Just some miscellaneous things, the whistleblower protections that were part of Sarbanes-Oxley, we talked about those. You can't retaliate. Understand that the board and management have responsibilities and liabilities, and that got spelled out in much greater detail in Sarbanes-Oxley. And then your property rights and what trespassing can do, and how those kinds of things can work. Then there was Violet, which we did, and before I get into this, any questions about the exams?
No.
Okay.
Is there a password to the exam?
Good question. I have to check. There may be, and I'll get it to you.
Okay.
I'll check. I'm writing that down right now. To exam. Okay. Just a couple of final thoughts, and these are just some takeaways from the course. I mentioned this before. You want to have your legal issue meter, and you seek guidance when it's triggered. So, even if you think you know the answers, it's probably best to run it by whether you have counsel. If you're a small business, you have an attorney. It's worth buying a half hour of your attorney's time to discuss something if it keeps you out of court. But also your human resources professionals. We had Paula Wood in, and someone like Paula is just gold because she knows the employment issues and the employment law so well. So it can be your human resources professionals. It can be your attorney. It can even be some online research. But you want to start developing that sensitivity that there are things that can get you into trouble, and you want to avoid them. Second is, I can't emphasize this enough, read every contract before you sign it. Understand the implications of every section, and don't hesitate to ask for changes. Remember these words: I'm not doing that. So it's really important. Just a couple months ago, I was talking to a friend who's an operations manager, and one of the things they have to do is ship out their product. And they use UPS for all of their shipping. And he was going on to me about how, God, our contract is so bad. I keep finding something new in the contract all the time that UPS throws back at me and says, this is why they did it the way they did it. And I said, hey man, you signed it. You didn't read it. You let the corporate attorney review it, but you didn't. You just said, if the corporate attorney's okay with it, I'm okay with it. And that's not a smart thing to do. Attorneys look at the legal aspects of it. They do not look at the operational aspects of it because they don't know your operation like you do. So you have to read it, and then part of it is you're going to negotiate changes. You need to know what you must have, what you cannot. You just can't abide by it. If it's, if you don't change this, we're not doing business. You know that, and you stick to it. But then you know what you'd like to have. You ask for all of it. And then if you give a little bit on the nice to haves to make sure that you get all of the must haves, that's a good deal. You've done well. But your negotiations always have to have the willingness to walk away from things that aren't, that could really do you damage. Somebody else will do business with you, I promise. And then the final thought I have is that legal and ethical aren't necessarily the same. So yes, you want to avoid legal jeopardy, but please, please, please do the right thing just because it's the right thing. And with that, I'll open it for final questions.
I don't have any questions.
No.
Going once?
Mr. O'Neill.
Yes, sir.
I did a very detailed for my business. I forgot which assignment it was either last week or the week before. Can I not turn it in, but can I add on to that and then put it for my business formation project?
Yeah, do it, but just let me know you did it.
Okay.
So that I know to look for it.
Okay.
Okay, and that's all. Otherwise, yeah, that's fine. And if it
what
won't let you upload it for any reason, then email it to me. But use the Ivy Learn system for email.
Okay. Now, what are your hours tomorrow if I can reach out to you?
My hours tomorrow. It's tomorrow, Wednesday.
Yes.
6 to 8. I'll be online 6 to 8.
Okay. On Zoom, right?
On Zoom, yep. And it's in the syllabus. How to reach me. It's this link. It's this same link.
Okay.
So yeah, I will be online 6 to 8. And if you need me for anything else, just ping me and tell me what time you're available, and we can set that up too.
Okay. Thank you.
That applies to all of you. If you guys need me, you know where to find me. And that goes beyond this course. What if there's anything I can do for any of you, you please let me know. Usually in the last class when we meet in person, I hand out my business card, but you all have my contact information. So you take a course from me, you get me forever as needed.
Thanks a lot, Mr. O'Neill.
Okay, and thank you all. I've had a blast doing this course, and I hope you have enjoyed it too.
Yes.
Yep.
It was amazing.
Yes, thank you.
Yeah, you're so welcome. What a great group you are. So.
Thank you, Kevin.
All right. Good night, all.
Good night. Thank you.
Good night. Thanks.
Good night. Thank you.
You still there?
I am.